at the law school. Tyler Giannini, second from your left, is the other director of the program. And the program includes both the Human Rights Clinic here at the law school and the academic side of the Human Rights program. And we conduct a variety of activities on the academic side of the program, which include debates and speakers and conferences, pretty much of the kind that we're going to be having today. For the bicentennial, I think I want to recognize the fact that we're trying to celebrate our bicentennial at a time when the role of law in the world and the role of law in the country is very contested and very important. And with that in mind, we want to talk about human rights law and how human rights law can go about making a difference in the world. Those of you who practice domestic law know that courts don't run things just by courts make decisions, everybody obeys, the world moves on as courts say it should. The study of constitutional law has included in recent decades much more attention to the role of social movements in making legal reforms happen and making sure that legal reforms get implemented. The speakers today come from a variety of different backgrounds. All of us are academics, but we have had a variety of different experiences in the real world of implementation of human rights. I do want to say that there's been one change in the panel, that originally the plan was to have the issue of the role of corporations in the implementation of human rights be discussed by someone who's currently employed by a corporation. The risk is that when you ask someone who's in business, business may require that person to go out of the country and handle situations. And so late in the day, we lost one of our panelists, and Professor Giannini has kindly agreed, though not employed by a corporation, or not a for-profit corporation, but active in the field of business and human rights, to fill in and talk about that part of the story. I myself, in addition to being an academic, have had the opportunity and the privilege of participating as a member of the UN Human Rights Committee, independent expert body that is the monitoring body for the Covenant on Civil and Political Rights. And it was very clear to me, both having studied the body before I joined it and seeing the operation of the body, that the Human Rights Committee is merely a piece in a large network of different kinds of players. What I like to say is that the Human Rights Committee brought impartiality and credibility to its interpretations and its findings, and that it could lend that impartiality and credibility, though it lacked power, to other institutions that had more power or more groundedness, and that together we produced results in the field of human rights. The speakers on the panel include Harold Hongju Ko, former dean and professor at Yale Law School. I hope that was not a Freudian slip, stumble in the pronunciation of that name. But importantly, someone who has served in the United States government, in the State Department, both as the head of the Bureau of Democracy, Human Rights, and Labor, and more recently as the legal advisor to the State Department. Viviana Krsticevic who, in addition to being an academic, is the executive director of the Center for Justice and International Law, CEJIL, a very important NGO, particularly in the inter-American human rights system. Tyler Giannini, whom I've already described. Makau Mutua, professor and former dean at the University of Buffalo School of Law, who has been a very important critical voice in the study of human rights. And finally, a non-lawyer, Professor Kathryn Sikkink from the Kennedy School, who engages in the empirical study of human rights implementation from a political science perspective. And she's actually brought a few PowerPoint slides.
So has Viviana.
You see these major disciplinary cleavages that we're going to be reflecting here. So the panelists are going to speak for a while, and then after that, I'd like to open the conversation to a broader conversation with people from the floor and the panel on this very important subject. With that, let me give the floor to our first speaker, my good friend Dean Coe.
Well, it's great to be back at Harvard Law School. It looks a lot different from when Jerry and I were here back in 1817. I wanted to start by paying tribute to some special Harvard Law professors. First, Henry Steiner, who is, of course, the founding father of the human rights program here at Harvard, and also the co-author with the late Detlev Watts of Steiner and Watts' Transnational Legal Problems, which frames human rights as part of a general set of phenomenon that face us in the late 20th and early 21st century. I was honored to be asked to join that book as a co-author, and it's been a great joy to participate in that enterprise. Second, Gerald Neuman, who I met my second year of law school. John Roberts brought us together. You may wonder how that is. He was the managing editor of the Law Review at the time. And that was a human rights experience equivalent to working in the Gulag Archipelago. And, I was assigned to meet Gerald Neuman to read text of a printed article against manuscript, which was what we did back in those days. And Jerry and I got together for what I thought would be a 15-minute speed read session. Instead, with every footnote or every sentence, Jerry would question the correctness of the proposition. We'd have a long conversation. So I was there for about 4 or 5 hours. And then Jerry said, well, if I knew it was so much fun, I would have made some cookies. So the next day, I go to my mailbox there from good old John Roberts, read against the second half of the same article again with Gerald Neuman. And when I went over to his house and we opened the door, I smelled the cookies. And we've been friends ever since, dear friends, about which I'll say more. Third, I want to recall Abe Shays, who is my professor. Jerry's also. And I think of him, he was the legal advisor of the State Department, a job that I was then lucky enough to hold. But he used to say, when asked about the Southern Baptist minister who's asked, do you believe in total immersion baptism? He'd say, believe in it. I've seen it done. So if the question is, do you believe that international human rights law makes a difference? I say, believe in it. I've seen it done. I could give you dozens of examples, but I don't have that time. But let me explain why. It's basically because of 4 different factors working together. My view, which I've expressed in many places, is that the core enforcement device in a system of complex enforcement of human rights law, as Jerry described, is the internalization of international norms into domestic law. But it comes from 4 elements. The first is universal standards, the standard-setting exercise that led to all of the treaties that started in the 50s and that has expanded with ambitious normative lawmaking, which allows you to say whether someone is meeting the standards or not, and to reject the notion that there should be double standards. The second is truth-telling. The human rights movement, I think, rejected the notion of alternative facts. You know, there was an official story, but there is a real story. And it is not only legitimate, but appropriate and necessary to get the real story out. And many heroic organizations, governmental and non-governmental, have devoted themselves to finding out the truth. And once you have the truth, you know, or you can tell whether it meets the standards. And that's a huge way of evaluating whether someone's acting in violation of internationally accepted norms or not. The third is the mechanisms. And there are many mechanisms, non-governmental and governmental, and they interact with one another. So Jerry described one on which he served brilliantly, the UN Human Rights Committee. But there are many others that function in a sort of ad hoc way on a case-by-case basis to both declare how the standard should be applied to the facts on any particular case. And what's fascinating about this is that finally there is a process by which these mechanisms intersect. I call it transnational legal process. But there are countless entry points, which means that individuals can make a difference, and committed organizations. And so this leads to what I think is ultimately the point of the exercise, which is when you have so many entry points, individual acts of courage and commitment can send forth what Robert Kennedy called tiny ripples of hope. That crossing each other from a million centers of energy and daring can sweep down the mightiest walls of injustice. And we see examples of this all the time. People in a hopeless situation showing courage or commitment or standing up, and suddenly something that you thought was impregnable is shattered. You know, for example, in our own country, the discrimination against same-sex marriage, et cetera. So I was asked to give some examples where I've seen this work. Let me give three. The first, Alberto Fujimori was the president and strongman of Peru. Viviana could say more about him. I met with him in 2000 with Madeleine Albright at the Waldorf Hotel. And he came in, and he looked like a man supremely in command. And, but what we knew at the time was that there were a series, 5 or 6 different human rights investigations going on about him, internationally and domestically. And when he left, somebody said, well, he's going to be in office for a long time. And I said, you know, I'm not so sure. You know, he looks like a dam under stress. And a week later, he fled to Japan, and he was done. Example number 2, I used to lead our delegation to the UN Human Rights Commission, now transformed into the Council. And I had to give a 10-minute speech about country conditions. And they had a big clock that was counting down. And so what we did was we drafted a speech that was about 18 minutes long for a 10-minute speech. And that allowed us to mention 25 country conditions. Although we knew that if we actually did the speech correctly, we could only mention 10 of those country conditions if I talk fast. So after we draft the speech, we would send it to all the capitals whose human rights practices we were challenging. And we'd send it to the ambassador in Geneva saying, if you don't release this prisoner or do this by noon on Thursday, Ko is going to call you out in his speech. Now, they didn't know that we couldn't include everybody in the speech. So all of these démarches were made. And on the morning of the speech, I'm sitting here with my aide, and there were 18 minutes of speech. And we had a whole series of signals from diplomats on our team who would come in and signal, like this would mean Sri Lanka did what we told them to do, and this would mean North Korea has just caved on this point. And they would come into the back of the room, they'd be doing this and this, and my teammate had this list of hand signals. And as I'm reading the speech, you know, the first 3 minutes are about China and Russia, take quite a bit of time. And these people are coming in the back of the room and signaling, and he's Xing out and recalculating and writing things like, speak faster. And by the time we got done, 10 different countries had come in and caved. So they would not be called out. We X'd out the time, and he wrote, speed up, and I finished it as 0. All just because of a speech. And then the last example involves someone who's here. I was a lawyer for Haitian refugees, and that was another good example of how human rights law can make a difference. We sued in the US courts against the Haitian interdiction. What was amazing was how many people rose up to take the side of the Haitian refugees. I see it today. Today we're filing a brief for the law clinic at Yale on behalf of 50 generals and military officers protesting the transgender ban. We filed a similar one on travel ban 1, 2, and 3. But in this case, we had to file a reply brief at the Second Circuit. It was my 3rd consecutive all-nighter, and about 4 in the morning, I just physically couldn't continue. I couldn't focus, and we were in New York. And somebody comes in and says that the brief is 28 pages long. We have to get it to 25. It has to happen in the next couple of hours. Are you going to do it? And I literally couldn't focus. And I called Jerry. It was 4 in the morning or something like that. And Jerry answered the phone, and I said, Jerry, I need you to come here and do this. I got to sleep. I got to sleep. And he said, OK, it's 4 in the morning. I said, here's the law firm. And I laid down and went to sleep under a table. And I had this vague impression that Jerry was in the room. And I could feel him moving around, and that made me feel better. And I slept a little bit more. And then finally, at about 11 o'clock, an hour before the brief was to be filed, he pushes me and he says, it's done. It's 25 pages. Read it once. And I woke up and I read. I made no changes because, you know, Jerry is Jerry. He should have written the whole thing, then I wouldn't have had to go through this. But what it did was this case gave this scholarly-looking law professor an avenue to enter the human rights world, to bring his brilliance to bear. That led him on to serving on the UN Human Rights Committee. It led him on to running this program. It led to him training now thousands of future Harvard Law graduates. It led to him triggering these tiny ripples of hope. That's why human rights law matters.
I just want to...
Go ahead.
Please hold your close to the end. I'm about to give the word to Professor Krsticevic, but first I need to issue an instruction to my co-director, which is there will be no personal reminiscences about me. I don't want you to think that was the reason why we called this.
I've got about 10 more.
So we'll save that for later when I have time for rebuttal. Professor Krsticevic.
Well, good morning, everybody. It's truly a pleasure and an honor to be here with all of you for this bicentennial celebration. I've been having fun since yesterday, and I think this panel is another reason to be joyous. I'm going to give you some of the examples of how I've seen it work. I want to talk about a couple of stories of how human rights law has affected individuals, but also how it has actually transformed and changed the history of several countries in Latin America. And I also want to end my very brief presentation talking about the transformational power of human rights law itself. So I run a human rights organization that represents victims before the Inter-American Commission and the Inter-American Court on Human Rights. We represent around 10,000 people and work with hundreds of human rights defenders and human rights organizations in the Americas primarily. And these bodies, the Inter-American Commission and Inter-American Court on Human Rights, can issue decisions. And for most continental Latin America, the Inter-American Court on Human Rights can actually issue binding judgments that can order compensation, but also what is called under international law measures of non-repetition. So they can go further, more in depth on the causes and consequences of the violations that have been demonstrated in a specific case in order, for example, for a law to be changed or a person to be prosecuted, such as a former President Fujimori, as it happened in the last decade. So the Inter-American system has had a substantial impact in at least 3 major thematic areas. It has not given these reparations to everybody that has accessed the system. It has failed many human rights victims in terms of doing justice for all. But it has affected the lives of millions, and including millions of human rights victims in our region. And the 3 areas where that has been more evident is in the issues of equality and non-discrimination, in supporting the rule of law and democracy, and finally on accountability. And because of the time that we have today that is a bit limited, I'm just going to focus on accountability. And as Professor Cole was saying, one of the beauties of international law in practice is that it has supported a narrative of historical events that has given more dignity and support to what victims went through. And it has made evident some of the gross violations of human rights that many have suffered. And that has impacted not only societies, but also individual victims that have had more of a sense of closure through the cases and the processes and the results of those cases. One of those stories is the one of the family of Marco Antonio Molina Thyssen, for example, a kid at 14 that was disappeared in Guatemala. And his sisters and mother are seeing justice being done because of this interaction of international law and human rights law. But in a more profound way, the development of standards on truth, on the right to truth, which is something that was novel, on disappearances, on amnesty laws, on access to justice, has also impacted the history of several Latin American countries. So my home country, Argentina, has been shaped by the fights of truth and justice for the disappeared and those that suffered human rights violations during the dictatorship. The imprisonment of former President Fujimori is also another very concrete example of human rights law international human rights law interacting with domestic social movements and the judiciary in Peru. And latest example is the fight for justice on behalf of the 43 students disappeared in Ayotzinapa, where the Inter-American Commission created a group of experts that has actually helped expose some of the corruption and violence that permeate the institutional structures and politics of Mexico. But I would say that, and we should get Kathryn to explain this better, but I think the histories of Argentina, Chile with the Pinochet case, and some of the works of the Archbishop's Office on the disappearance, Colombia, Guatemala, Honduras, Peru, cannot be understood without human rights law. There's a very strong relationship of, 2 minutes. Of how human rights law and the idea of human rights law even without these institutions, can actually shape the realities of different countries. And I've seen it working very powerfully in Latin America. I think human rights as a tool itself is a very important tool. It has been a shared yardstick for some of the fights global and domestically for many human rights organizations and individuals. It has provided this common language and this possibility of convening people and finding ways of moving forward with others. It has forged alliances and solidarity in the countries and outside the countries. And probably Professor Makau Mutua is going to talk about some of the tensions that on the structures and the language of human rights. And I recognize those tensions and that human rights law is not a static process. What I want to say is that sometimes human rights law, when taken up by individuals and organizations and societies, can also have a very transformational power. And so it's like a cyclical thing of those communities having an impact on how international law develops and how the reach of international law. So I just wanted to end my presentation with the words of one of our friends and colleagues, Abel Barrera from Mexico, who works in the mountains of Guerrero, because I think he goes to this point in a very incisive manner. And he says, in the context of social polarization and disenchantment with political parties, insisting on the transformational power of human rights on behalf of those most excluded from society may seem futile. But from Tlatinola in the mountains of Guerrero, the way in which individual victims and communities take human rights and refine them underscores the fact that human rights have the potential to break the walls of impunity. The fights of victims have shown us that human rights are a force that can transform institutions that are stifled by corruption and can help dismantle the criminal structure which permeate the higher echelons of power. So I want to challenge you with that idea. Even without institutions, even without international organizations that apply it, human rights law and human rights as an idea is a powerful concept, is a powerful construct that helps us know what is right and wrong, what is true and false, and can help transform realities very profoundly.
Thank you. Professor Giannini.
Okay, so no stories, huh? That's not so fun. Not of you. Anybody else on the panel? So fair game? Okay. All right. So I'm kind of sort of pinch hitting. I don't work for a corporation, but I'm going to talk about corporations and business and human rights. And I have been working in this space for about 20 years, so hopefully I took the invitation as a chance to kind of reflect back. And I altered the question a little bit. My first question was not how does it make a difference, but does it make a difference? And for me, the first thing that came to mind is kind of depends on how well I sleep the night before. That's really what it comes down to. And maybe there's another one. So it depends on if I read the news that morning. I didn't read the news this morning, and I had a good night's sleep. So I actually think that today I'm in a pretty good space in terms of I think it does make a difference. Second question I asked is, how do we see if there's a difference? How do you actually look at that and get if it's happening? And part of that back and forth for me is that sometimes when you talk to a colleague who says, I lost a client, they disappeared. They brought a case, a human rights case, and that's going to keep you up at night. That's going to really make you question whether there actually is usefulness in doing this. Other times, you go to talk to somebody about housing rights, and you're in a place in a tenement where people really shouldn't be living, and you see a 5-year-old child, and you wonder, I can't really do much for this particular child right now. I can report back, I can tell some truth about their experience, but is it going to make a difference to them before they have to grow up? And that makes you question whether you're making a difference. So you have those moments pretty often, but then you also have the difference-making times. And I work with colleagues who are in this room who can talk about their successes, like winning victories to get school buses so kids don't have to walk 3 hours to get to school in South Africa. That's a moment where you can see the difference that's tangible day to day. Or I can look at my colleagues who have worked to pass treaties that ban cluster munitions or ban nuclear weapons. That's the day when you pop the champagne, right? That is really important. And those moments don't come every day, but you can swing back and forth in major ways. And that's part of the problem, I think, for us is how long are you looking? Are you in a small moment, or are you looking at the system over 20 or 30 years? There's other small moments that I can look to. You talk to a client who's in a deposition sitting across from the alleged perpetrator. And from a legal perspective, you're worried about the impact. Like, that deposition didn't go so well. But then the client says, I got to sit in the same room with the person and confront them. And that makes a difference to that person that day. Or if you get students released for protesting their right to education in Myanmar, those days matter, and we have to latch onto them. And so this swing back and forth is really important to me, and I was thinking about it. But as I reflect back on business and human rights, where I went with the conversation in my head, because it's the 200th anniversary, I started to think about, where was this 200 years ago? Is there anything that you can draw on then in the United States, for example? And I thought about slavery, but I thought specifically about slave trade. Slave trade is business. And in the early 1800s, it wasn't outlawed internationally. It was contested. But 30 or 40 years later, we could look back and say, it's outlawed internationally. And so if you start to look at that, it wasn't framed in terms of human rights, but I think we would say that's a human rights issue. And it was interacting with powerful economic interests. And so that idea became a powerful transformative moment, very contested because of the powerful actors involved. Of course, that's what you expect, but you did see change over time. In a more modern context, the work that I've done has been in the, can you hold corporations liable for human rights violations under international law, under human rights? And the big case in that space is, one of the big cases was a case called Makau, involving facts out of Burma, or Myanmar, I should say, today. And it was a forced labor case. It's actually a modern form of slavery. And it raised this question, could you sue a corporation for human rights violations? Very relevant question. That was brought in the mid-1990s. We're still dealing with that question. The Supreme Court addressed that question 2 weeks ago in a hearing. We'll see how they resolve it. But that's a very important question for this fundamental space of business and human rights. If I look at that Makau case, what I see is the case, after 10 years settled, had an impact on the individuals involved. Their story was told. It also created a fund, which still operates today and is doing development work inside the country. That makes a difference. What I saw was the boardroom of the corporation talking about human rights. What we also saw was that the case settled 2 weeks before Makau was bought by Chevron. We think there's a relevant relationship there, that the human rights liability potential impacted the sale, and they wanted to clear the liability before Chevron bought it. That's impact. You also see a backlash from the defense bar, many litigation efforts to stop these kind of cases. That's also, I think, an indication that there's actually something that matters here. You also see that these kind of cases that were brought under something called the Alien Tort Statute. I got 2 minutes. I think I'm on track, actually. That other countries are now trying to do similar things. So you plant a seed and then it grows in ways you can't predict. So in the United States, in 2013, there was a setback in the corporate cases under a case called CEJIL, a case out of Nigeria. And it has constrained the ability to sue corporations in the United States. So that's a setback, in part because the defense bar was litigating it so hard. So that reaction was what we see, that ebb and flow. And then, as I said, in the Jesner versus Arab Bank case, a case to watch if you want to see what happens in this space. It's the same question that was originally posed in CEJIL. Can a corporation be sued for human rights violations under international law? And so the Supreme Court has taken that question twice. If that question doesn't matter, they're not going to take the case. And so this is, I think, where we see human rights impacting the entire space. And that's impact. And so sort of my final thoughts on this were that I see difference in a few different ways. One, you see the personal moments that matter to people. That person that got to confront the perpetrator, that person that got a settlement that changed their life. That matters at that moment. You see it also impacting the people who are doing the bad deeds. Corporations have to address these issues in ways they didn't have to 30 years ago. Boardrooms have to think about them. They have to think about how to prevent them. Big law has to think about how to defend this. That makes a difference. Institutional systems are responding to the issue. The Supreme Court's an example of that. That's a big institution thinking about a really important question. And the last piece I put under I think it's similar to what Viviana was saying about the transformation, the ideas. The ideas themselves, the question of whether you can sue a corporation is front and center now. That wasn't there 30 years ago. And I think if we go 30 years into the future, that question will be answered in favor of corporate liability. So it will be like the slave trade. It's contested now, but it will become accepted. That's impact from human rights. And for me, the measurement of that big question about how do you see if there's a difference, because there's actually a response. That's what I look for. If it didn't matter, there wouldn't be the backlash. There wouldn't be the response. But because the response is so big, I think it's making a difference because it's powerful. So I'll close there.
Thank you very much, Jerry. And I know there are no reminiscences for you, but I would be remiss if I didn't recognize Henry Steiner, with whom I worked in the human rights program here for many years, and who taught me human rights law in this law school, and who founded the human rights program. I think, Henry, we owe you a huge debt of gratitude for what you've done for this program and for the school and for us. You know, having said that, I just want to make it clear that, you know, all the comments I make are mine. Nothing is to be imputed to Henry. Especially the comments that are controversial, because I know that there's a place in hell that is reserved for people who criticize human rights. Let me just say that I don't disagree with anything that's been said by my esteemed colleagues. You know, a lot of it is true, and I agree with it wholeheartedly. But I just want to say that we could not stop there, you know, at where they have ended their analysis. I think on the basic question as to the kind of effect and impact that human rights have had on the world, I think it's clear. You can look at the normative penetration of equal protection norms and anti-discrimination norms in most cultures, in most states. And that will be indisputable. You just need to look at constitutions. You need to look at penal laws. You need to look at due process protections, which are provided for in many jurisdictions around the world. And you will see that those two ideas, which to me are the pillars on which the human rights movement stands, have been quite effective. As an empirical matter, we can also adduce evidence to show that the idea of human rights has been very impactful. We can look at the conduct of states towards their own citizens. We can look at the establishment of both international and national mechanisms for accountability for violations. And we can quantify the impact or the mitigating impact of some of those measures. But I think that we have to take a step back and situate the human rights text and the human rights movement in context. While it is true that there's no country that is going to be standing up, no state that's going to be standing up and waving a flag saying that it's proud to violate human rights because human rights are perceived as a public good. We have to look at some of the tensions in the human rights movement and the human rights text. And those tensions, are very serious. First of all, I think we should not wash away or pretend that the human rights corpus does not come from a philosophical tradition that is anchored in the liberal project. I think we have to, first of all, accept that as a starting point for our conversation in assessing not just the impact, but the import of the human rights project. And if we start from that basis, the second level question for us to ask then would be, how did we get from the liberal project, which is a child of the Enlightenment, to universality? How did we universalize these ideas? How did they get embraced? And why did they get embraced? Is there a connection between the human rights project and the hegemonies of certain powerful states, especially in the industrial West? That is one question that clearly we should ask as we talk about the impact of it. Secondly, we want to ask the question about the cultural legitimacy of the human rights idea. It's one thing for an idea to be effective in a society. The slavery was an effective system, as was colonialism. But was it a moral idea? So effectiveness is one measure, clearly, of looking at a particular project. The other is to look at whether that idea has cultural legitimacy. And if the human rights project is lacking the writ of cultural legitimacy, the question that we want to ask yourself is, why is it lacking the writ of cultural legitimacy? Is it because it is not receptive to the interpenetration of ideas from other cultures? And because there, I think, even as we talk about effectiveness, we want to ask ourselves about the depth of the embrace of different cultures of the human rights idea. How deep is that embrace? Is it an embrace that is irreversible? Is it an embrace that has transformed other cultures? And if it's an embrace that has transformed other cultures in a fundamental way, is that a good thing? And then there are questions of, I think, normative incompleteness of the corpus itself that I think we have to address. And one of those questions about normative incompleteness have to do with a question about powerlessness. Is a human rights idea able to formulate, if you will, a set of norms and processes to get to deeply embedded social dysfunctions and social inequities? My own critique of this is that the human rights idea, has not been able to figure out how to deal with economic powerlessness. It is very comfortable in the terrain of political powerlessness, of containing political despotism, but it is not capable, in my view, of addressing economic powerlessness. As such, what we see is, a kind of collaboration between the Human Rights Project and capital in ways in which the Human Rights Project is not able to completely understand capital and to create a response to it. I'm old enough to remember the heyday of the human rights movement, and I put the heyday as the 80s and the 90s. Every time the language of rights was mentioned, our hearts would palpitate with hope. And you saw during that period a flocking of, people in different societies and interest sectors to the use of the rights language to try to vindicate their claims and to reduce their powerlessness. What we've seen in the last, I would say, 15, 20 years is a retreat of human rights, a sort of a slow burn of fatigue of the human rights idea. So that today, even if you go to a law school, I remember, in the 90s, if you came to Harvard Law School and you wanted to take a class in human rights, the class was always full. Today, I don't know what the numbers are here at the law school anymore. But in my law school, for example, I remember when I began teaching in Buffalo, New York, I would get 60, 70 students. Today, I'm lucky to get 15. The idea is dying slowly, and I have been forced to ask myself this question: why is human rights no longer the idea of the moment? Now, most great ideas have a shelf life. 60, 70 years, they come and they go, or they just become passé. Have we arrived at that point that the human rights idea is a passé idea? And if that is the case, we need to ask ourselves, why is that the case? And what idea has replaced the human rights idea as the moral idea of our time? Because human rights clearly has been the preeminent moral idea of our time. What has replaced it? And I would argue that although this vacuum is developing, nothing has replaced it, which is a very interesting challenge to all of us as practitioners and as academics. I have some notion as to why this is the case. I think that the human rights idea, just like the idea of democracy as we know it, has reached a stage of stasis. It is kind of metastasized and become sort of formalistic and being trapped in this in a sterile sort of capsule. That we are not able really to go beyond the basic normative prescriptions of a traditional democratic society. We're not able to do it. We see, for example, in the United States, we see it in Western Europe, we see the challenge to the liberal idea. You know, we've just elected someone in this country who wants to overthrow that idea, and has been supported by a very large percentage of the American population who have soured on the idea of the liberal project. You know, there are calls to authoritarianism, again, open calls to authoritarianism, including even from the President of the United States. So this idea is in retreat because one of its homes is rejecting the idea of human rights. And the license, obviously, that this has given to others in other societies where the idea was never deeply entrenched in the first place to reject the idea. So one of the challenges that I think I want to leave with you, you know, Dean Coe and others, is how can we reimagine this idea? I have this sense that the dynamism of the human rights text has died. You know, we keep on revolving around equal protection and anti-discrimination as our core, you know, northern lights. And I don't think that's getting it. I think that we need something more. We need to address economic powerlessness in a way that is more serious. And we need to deal with other cultures in a way that actually accepts that they have a normative contribution to make. I think it's okay to say that, you know, Islam is fine, or the Islamic tradition is fine, the African traditions are fine. You know, we need to ask ourselves, what in this human rights idea that we have today is taken from those cultures? And I think that, you'll be hard-pressed to find a bandwidth, you know, a normative bandwidth that shows you that, you know, the receptivity of the human rights idea to normative ideas from those other cultures. And I think that is part of the problem. You know, so I just want to end by saying that there's a fatigue. And I also think that, you know, I don't want to declare the death of human rights, you know, or the end of the era of human rights. But I'm coming very close to that particular point. The only thing that is making me hesitate is because there's nothing else. There's a vacuum. Nothing else has arisen to displace human rights as the idea of the moment. So I'll leave it there, and we can have a conversation later.
These are the kinds of conversations we like to have at the Human Rights Program. And we also like to bring interdisciplinary perspectives of other kinds, as Professor Sikkink is about to do for us. You want to sit?
Yes, because I have a mic here, right?
Great, perfect.
Okay. Thank you very much, Jerry, for the invitation. Like Tyler, I think it's hard to answer the question how human rights have made a difference if you can't answer the question if human rights have made a difference. But I would like to think that it's more than just how I slept or whether I read the news, but I would like to think as an empirical social scientist that it's based on the best evidence that we can bring to bear. So I'm talking about a book I've written today. I'm talking about this book because in this book I directly try to answer the questions of this panel. The book is about the legitimacy and the effectiveness of human rights. The first part of the book is about the legitimacy question, and it takes very seriously the contributions of other cultures, not for the future, but it points out that our history of human rights is often told inaccurately because it does not recognize the contributions that other regions have made. Latin America, I spent a lot of time on Latin America and its contributions, but also Africa, for example. We forget that the first transnational human rights campaign of the late 20th century, of the 20th century after the Universal Declaration of Human Rights was the anti-apartheid campaign, and that the decolonization movement was not only about sovereignty, it was about human rights, and that the contributions of activists and diplomats from all around the world built the human rights movement we have today. But today I want to talk more about the effectiveness question, though I think we should engage with the legitimacy question that Professor Mutua raised as well in the question and answer period. And it's so important for exactly the points that Professor Mutua just made. There's this notion of fatigue, slow burn, death. There's books that have names like The End Times of Human Rights, The Twilight of Human Rights Law. And so I just want to read from the one point from The Twilight of Human Rights Law written by Professor Eric Posner here. He says, quote, unquote, countries solemnly intone their commitment to human rights. They ratify endless international treaties and conventions designed to signal that commitment. At the same time, there has been no marked decrease in human rights violations. The law doesn't work. We should face that fact and move on. Now, I'm a social scientist, so I think that the issue of whether there's been no marked decrease is an empirical question, and I wanted to try to bring evidence to bear to that question. So I looked at all the databases at my disposal. I tried to choose data that most of us would agree would be good data that would reflect commitment to human rights. That would reflect enjoyment of human rights. So there's two questions here that Posner raises. Has there been no marked decrease in human rights violations? And secondly, what's the role of human rights law, institutions, and activism in that situation? And his notion, the law doesn't work. And so I don't have time in a few minutes to address those, but excuse me. But it's very important, and it's important for the mental health of human rights workers who, no, it is. Part of this fatigue, no, okay. Part of this fatigue and slow burn, part of this hopelessness is in part because people believe and are being told that they have made no difference. So there's actually research showing that human rights workers suffer from depression. One source of depression is that people believe that they have not been able to make a positive difference in their work. Okay, and so the issue is, do we have evidence for that? And when you look closely at the evidence, what you find is there's some evidence of situations that have gotten worse. The refugee crisis today is a good example of that. There are more refugees on the move than ever before since World War II. But there are many, many other issues where we see improvements, and even things related to this refugee crisis. If you look at the number of annual battle war deaths, for example, you find that there's a dramatic decline in battle war deaths. This is related to a decline in war. Okay? So simultaneously, we have fewer wars, but more refugees on the move as a result of war. I'm working on this issue, and I have some evidence, some quantitative evidence, that suggests that one of the factors, not the only or the most important, but one of the factors that has contributed to the decline of war and the decline of battle deaths in war is law. Laws about, including the UN Charter. Okay, and in this, I'm connecting to some work that Ona Hathaway has done, and her new book takes us back actually to the Kellogg-Briand Pact and has a re-evaluation of the importance of the Kellogg-Briand Pact as starting this trend towards a decline in war. But there's also a decline in genocide and politicide. That you see the peak here in the 90s, the 70s to 90s, with the decline afterwards. This is a measure of episodes of genocide and politicide, not actual people affected. The closest I can come to that in terms of people affected is a measure called one-sided violence. That is lethal attacks on civilians by governments or formally organized groups. This data here is with data about Rwanda removed. And the reason I've removed in this one, or they've removed in this one, the data about Rwanda is if you put Rwanda in the data, it dwarfs everything else so much that literally there's a flat line, there's a big peak for Rwanda, and there's a flat line. Okay, so we take it out not because it's not important, but because it's so important that you can't see any of the variation in the data otherwise. The other issues that are connected to the human rights movement, maybe more obviously connected, would be the decline in the use of the death penalty. As you know, Amnesty International made it the center of its campaigning from the 1970s when they started. I have the number here. I think there were 16. When Amnesty started, before this chart started, I think there were 17 countries that abolished the death penalty in law. Today, we have about 100 that have done it, or if you look law and practice, abolished death penalty in law and practice, 140 countries have done that. By practice, it means you haven't used an execution for 10 years. People will be asking, what about economic, social, and cultural rights? I disagree. I think the human rights movement, certainly in Latin America, has gone, but also in some things that are going on in South Africa today, has moved dramatically into litigation around economic and social and cultural rights. There's a lot of dynamism in that area. But if you look what's happening with some core rights, I'm using famine here as one of the most extreme examples of violations of economic and social rights. The orange line is the line on Great Famine. The green is population growth. So what you see, I could chart most of the data I'm giving you, I could chart it in this same way against population growth. And it would make even clearer the question that a lot of the improvements we're seeing are against expectations given all the population growth. So we have war going down with dramatic population growth. We have famine, great famines almost no longer existing. Despite population growth. Now, people will say, of course, famine, but what about hunger? So here's data on global undernourishment. The orange line is the actual number of people undernourished. The brown line is the percentage of people undernourished as a percentage of population. You'll see both the orange and the brown are decreasing. They're not always decreasing as much as we would hope. And so the dotted lines are actually, one is the multilateral development goal. You see the prevalence of undernourishment has met the multilateral development goal target, but the number of people malnourished has not met the target that the World Food Organization set. The desire was to halve the people undernourished, and that has not been accomplished. I think another good measure of an economic enjoyment of an economic and social right is infant mortality, because it tells us a lot about maternal health, access to health care, access to clean water, etc. This is a table that projects to the future, so it projects to 2050, but you see 2015 is about 2/3 of the way through here. The point being that infant mortality is declining everywhere in the world, but there's different patterns in different regions of the world. And so there still are much higher levels, of course. Then the yellow line is Africa. Very dramatic improvements in Latin America, for example, which is the kind of orange line. So we still have to be attentive to these regional disparities and regional differences, and not just, of course, celebrate improvements, but say, how can we learn what has contributed to these changes so that it can be reinforced and deepened in the future. And there's finally, this is data on women's gender inequality in education. So it's a Gini coefficient. Gini coefficient is what we normally use to look at economic inequality. In this case, we're using it to look at the decline in gender inequality in women's education. Okay, so these are 5 measures of women's education: years of schooling completed, primary, secondary, tertiary. And we see in all those areas, global trends show a pretty dramatic decline in gender inequality in education. And if you look at the regional data here, which I have, you'll find this is happening in all regions of the world, including the Middle East, which is quite interesting and contrary to what we hear in the news sometimes. So I could keep going on, but I'm running out of time. But I just want to say that this is so important because we have this problem of, of burnout, right? And I think the burnout is related, in fact, to a sense of hopelessness that nothing we do matters. And so some of this evidence is not intended to be triumphalist, to act as though our job is over, but rather to give us the evidence we need to know how to move ahead in the future, because we really can see what works, what doesn't work, and where, so we can do that more in depth. Thank you.
Thank you. So we may have evidence for hope. We certainly don't have reason for complacency, but we're not gathered here in the thought of being complacent. I'm going to ask for interventions from the floor in a moment, but I think I've seen an intervention from the panel.
So, look, I love Makau. He's a great human rights lawyer. I think one of the concerns I have is that the left and the right often meet in the zone of pessimism and cynicism. About Eric Posner, so he hasn't seen it. Well, guess what? The human rights movement is not happening where he's been. It's not happening in the faculty lounge. It's happening. It's happening in refugee camps, and it's happening in courtrooms, and it's happening in NGOs and places where people are fighting. So, it's great to sit there and be dismissive, but guess what? Nobody said it's easy. When I was graduating from Harvard Law School, having no thought that I would ever do human rights, I say to my mother, I'm thinking about working for this big law firm or that big law firm, and I agonize and I agonize. And she says to me, do they need you the most? Do they both need you? Do either of them need you? And I said, what are you talking about? And then she said, you have the best education in the world. We gave it to you. You have the most privilege. Isn't it your responsibility to work for the people with the least privilege? If you care about equality, don't you want to fight for it? If you care about freedom, don't you want to fight for it? If you care about dignity, don't you want to fight for it? The arc of history is long and it bends toward justice, but it doesn't bend by itself, so you have to put yourself somewhere in this fight. And, there will be the Eric Posners of the world. And guess what? He's not going to be the one who moves the arc toward human rights. And, if you go and work with someone who has a huge amount of resources, you don't have to be a very good lawyer, and they can get anybody. But in this business, the odds are so bad and the stakes are so high, you have to be a fantastic lawyer to succeed. And why do you play video games? I'm sure most of you play video games. So that you win? Most of the time you don't win. You play it so you get better, and you learn from your mistakes, and that next time around you make the difference that you didn't make the first time. I mean, this is a long, long fight. And maybe it's not new to us anymore, Makau, but it's new to each generation. That's the answer to the burnout, that the next generation doesn't buy that there's no fight to join in and that they don't have a role to play in that fight.